Good afternoon. I'm very pleased to welcome you as the Dean of Law to this wonderful talk we have planned this afternoon. We have an absolutely amazing guest speaker this afternoon, Baroness Hale of Richmond. Lady Hale is a leading academic and also the first and only woman to have been appointed to the Judicial Committee of the House of Lords. From there, she was transferred over into the Supreme Court when that was established as a result of constitutional reform in 2005. And she was indeed the president of the Supreme Court until her retirement a short time ago. Last year, we were celebrating 100 years of women in the law, the changes in the law that allowed women to actually practice as barristers and indeed in other professions. And I think that Baroness Hale is an absolutely magnificent example of why it was absolutely right to bring women into the law. She's going to talk to us today about a subject that's been very close to her heart, which is family law in the 21st century. So I'm going to hand over now to Baroness Hale of Richmond.
But I think I see your Vice-Chancellor on the screen, so it's very nice to see you. I know you've been very much occupied in a Senate meeting, but if there's anything that you'd like to say, I'm sure your audience would love to hear it. You're mute.
Baroness Hale, I would like to say apologies. I came in a little bit late there, but it's a really great honour to have you here with us today. My colleague Sandra has introduced you well. She's given you some of the acclaim that you deserve. What she didn't mention, I don't think, was though that you were a judge on MasterChef, and this was a very important accolade you've had. Although I do believe your teacher at school said, or your cookery teacher would sigh when you walked in. Anyway, but it's great to have you here. It's really good. Looking forward to what you're going to say, and thank you for joining us. Thank you for coming to Buckingham, virtually at least.
Thank you, both of you, for the invitation and for the introduction. And I have a very large subject to talk about, which is family law in the 21st century. A lot has happened in family law since the 21st century began, and we're only a fifth of the way through. So a decent parlour game for family lawyers will be trying to work out what will happen during the rest of the century. And I commend that to you, Professor Clark, for an idea for a Christmas game for your students. We tend to think of family law as what happens in the family courts, but that is only part of the story. Family law does at least three things. First, it defines our relationships, which of them count for legal purposes and which do not. Secondly, it grants formal recognition with legal consequences to some relationships which would not otherwise have them. And thirdly, it provides remedies when things go wrong or the need arises. And that, of course, is what the family courts mainly do. So firstly, defining family relationships. We all have our own ideas of who the members of our family are. But by defining and granting legal recognition to only some of these, the law has traditionally excluded rather than included. The modern trend is decisively in favour of more and more inclusion. Traditionally, family relationships were defined by affinity and consanguinity. Affinity meant heterosexual marriage. Consanguinity meant blood relationship. But for most of history, consanguinity only counted if the relationship was traced through marriage. Children whose parents were not married to one another had no legal relationship with their father or their father's families, and only a limited relationship with their mothers, however close a family they in fact were. The most significant changes to this exclusionary rule were made during the 20th century. Children whose parents were not married to one another became full members, not only of their mothers, but also of their fathers' families. for almost all legal purposes. But it went further than that. Section 1 of the Family Law Reform Act 1987 is one of the most important reforms to stem from my time at the Law Commission. It sounds dry, but it means a lot. References to relationships in legislation and legal documents, such as wills and conveyances, are to be construed without reference to whether a person's parents or the parents of anyone through whom the relationship is traced were married to one another. So a gift to my nephews and nieces includes my sister's children, even if our parents were not married to one another or she was not married to their father. So there's no need to include them expressly, although they can be expressly excluded, and there is no need to have an adjective describing the children. Illegitimate should have left the language. There was, however, still one difference. Just because the child now had the same claims against the father and the same legal relationship with his family, it didn't follow that the father should automatically have parental responsibility for bringing up the child. Such is the variety of circumstances in which these children are born and grow up, that unmarried mothers were worried that their lives might be made even more difficult. At first, therefore, the father could only acquire parental responsibility by agreement with the mother or by a court order. So one of the earliest inclusive changes in the 21st century was to expand this to include fathers who are named on the birth register. It still usually requires the cooperation of the mother, but it means that the great majority of fathers are now included. The other 20th century change affected fewer people, but was nonetheless dramatic. The 1987 Act provided that the husband of a woman who had a child as a result of donor insemination was deemed to be the father for almost all legal purposes, unless it was proved in court that he didn't consent. A radical departure from the normal rule that parentage is a genetic rather than a social relationship. The pressure came from doctors who were treating couples for male infertility and sympathised with their wish to pretend that everything was normal. Doctors pointed out that studies had shown that a remarkable number of children were not in fact the genetic offspring of their mother's husbands, although registered as his. Others pointed out that there was a difference between the mother and maybe her husband concealing the truth and deliberately altering the truth by law. Be that as it may, once made, the new rule had to be extended to the children of unmarried couples, as well as to children resulting from in vitro fertilization or embryo transfer using donated sperm or eggs. The Human Fertilization and Embryology Act 1990 laid down that the woman who carried and gave birth to the child was always the mother, thus prioritizing gestational over genetic maternity. It also provided that the mother's unmarried partner would be deemed the father if they were being treated together in a UK licensed clinic. But the most dramatic development of all had to wait until the 21st century. No longer did a child's parents have to be a man and a woman, a father and a mother. In 2008, the rule was extended to female same-sex couples. The ambiguous concept of being treated together was replaced by a simpler and clearer system of written consents for both opposite and same-sex unmarried couples. There has to be a valid consent from each partner at the time of the insemination or implantation for the man to become the father or the other woman to become the second mother of the child. In this way, the law has radically altered the relationships of children born using donated gametes, and it applies for almost all legal purposes. If you leave property to a class of relatives, such as your grandchildren, they will be included. Is this the end of the road? Or could we envisage other changes to the automatic parentage rules? What about surrogacy? Could we contemplate the commissioning parents becoming parents without the intervention of a court order? Could we contemplate a child having 3 parents and 3 parental families? Just a thought. So moving on to formal recognition and status. Family relationships don't only arise at birth, they can be created, either by the act of individuals or by court order. The paradigm of a formally created relationship is, of course, marriage, famously defined in 1866 as the voluntary union for life of one man and one woman to the exclusion of all others. This rules out actual or even potentially polygamous marriages in this country. But the parties to valid foreign polygamous marriages can seek divorce and associated financial remedies here. Could we ever foresee the law recognising actually polygamous marriages in this country? But in this century, we have moved on from the notion that it must be one man and one woman. This is perhaps the most surprising of the recent changes in the law's ideas of a family. As late as 1988, the Local Government Act was amended to prohibit the teaching of, quote, the acceptability of homosexuality as a pretended family relationship, end quote. But in Gaiden and Godin Mendoza in 2004, the House of Lords held not only that a same-sex couple could indeed be living in a marriage-like relationship, but also that the words living together as husband and wife could be interpreted to include such a relationship. Later that year, Parliament passed the Civil Partnership Act 2004, creating a formal status for same-sex couples which was almost identical to marriage. At that stage, the lesbian and gay community wanted a distinctive status just for them, partly because they didn't want to put off the traditionalists with talk of gay marriage, but also because if it was reserved to them, it could have almost all the legal consequences of marriage. If opposite-sex couples could also choose it, they feared that the consequences would be watered down so as to preserve the attractions of heterosexual marriage. But things moved on remarkably quickly. In 2013, Parliament passed the Marriage Same-Sex Couples Act. Same-sex couples could now choose between marriage and civil partnership. Instantly, therefore, opposite-sex couples were discriminated against because they had no such choice. Astonishingly, it was not until the case brought by Rebecca Steinfeld and Charles Gaiden reached the Supreme Court in 2018, 5 years later, that the courts acknowledged that this was unjustified discrimination in their enjoyment of the right to respect for family life. Why the government fought it so long is a mystery. Perhaps they were unsure of what to do to put it right, but that shouldn't have prevented the courts from telling them that something had to be done. As with most discrimination, there is a choice between levelling up and levelling down. Making both marriage and civil partnership available to all, abolishing civil partnership, making marriage the only choice for all, or, as I think would have been perfectly rational and workable, abolishing marriage, making civil partnership the only choice for all, leaving those who wanted a religious ceremony to organise it privately. In fact, Parliament quickly pushed the government into choosing the first option. And 167 opposite-sex couples registered a civil partnership on the 31st of December 2019, the first day that it was possible to do so. Figures for 2020 are not yet available, but I doubt that demand will be high if the views of same-sex couples are any guide. Now that marriage is available to them, many more same-sex couples are choosing it than choose civil partnership. In fact, marriage is the fastest growing type of same-sex relationship. So, although both the number and rate of marriages has been falling since its peak in 1972, and the average age at marriage has risen by 11 years since around the same time, 4 out of 5 cohabiting couples whether of the opposite or same sexes, and with or without children, are either married or in a civil partnership. Marriage still exercises a tremendous pull. Of course, marriage and civil partnership change your status without a court order. But there are two court orders which also bring about a change of family relationships: adoption and parental orders. Adoption has been with us since 1926, and since 1975, an adopted child has been treated in law in almost exactly the same way as a child born to the adoptive parents. Not just their parental responsibility during childhood, but a full member of both their families. The dramatic change in this century was to open up adoption to unmarried couples, whether of the opposite or the same sex, provided that they are living as partners in an enduring family relationship. This would, of course, have been a great deal more problematic had the Family Law Reform Act 1987 not already recognised family relationships traced otherwise than through marriage. And the same now applies to commissioning parents in surrogacy arrangements, who may be married, civil partners, or living as partners in an enduring family relationship, or single. Provided that one of them supplied the gametes which created the child, they can apply for a parental order. This transfers parentage from the surrogate mother, and possibly her husband or partner, if they would be the other parent by the rules of English law, to the commissioning parents, without their having to go through the whole adoption process. Attitudes to surrogacy have also changed dramatically during this century. The courts have proved remarkably sympathetic. In theory, the application must be made within 6 months of the child's birth. But the former president of the Family Division held that this could be relaxed, and orders are regularly granted for much older children. In theory also, no money must change hands in return for the surrogacy arrangement, other than reasonable expenses for the surrogate mother. Again, it was held that the court could approve such payments after the event, thus enabling orders to be made after foreign commercial surrogacy arrangements had been completed. Indeed, the Law Commission is not aware of any case in which an order has been refused because of payments amounting to more than reasonable expenses. This isn't surprising. The child is here, living with the commissioning parents, may have been born in a place such as California, which regards them as the legal parents. And so the child will be left parentless, familyless, and possibly even stateless if an order were not made. In the last judgment I wrote before my retirement, the Supreme Court decided that commercial surrogacy is no longer contrary to public policy. A woman who has been wrongfully deprived of her childbearing capacity may claim damages, not only for an altruistic surrogacy arrangement here, but also for a commercial surrogacy arrangement abroad, provided that it is reasonable to choose that option. Of course, there are many commissioning parents who would like the law to go further and recognise them as parents without the need for a court order. The Law Commission has provisionally proposed a pathway which would enable commissioning parents to be recognised as parents immediately the child is born. But the Commission cautioned against a three-parent model in which the surrogate mother remains a parent along with the commissioning parents. And of course, our model of adoption is a transplant of parenthood rather than an expansion. Except that now a step parent can adopt without the birth parent having to do so. So for the time being at least, a child can only have two parents and parental kin. Might that be the next frontier? So lastly, turning to remedies when things go wrong. Family court judges like making adoption and parental orders. Whatever the traumas leading up to them, and there may be many, these are happy occasions of huge significance both to the child and to the parents. This is in stark contrast to what the courts spend most of their time doing, which is finding a remedy when things have gone wrong, often very badly wrong. Remedies to protect against domestic violence and abuse, remedies to sort out the arrangements for the children when their parents split up, remedies to protect children from abuse and neglect in their own homes, remedies to dissolve a marriage or civil partnership and sort out what happens to the home, any other property, and the family finances when married couples or civil partners split up. Once again, major reforms took place in the 20th century, and until recently, there had only been quite minor changes to the remedies in this. However, in 2017, The Times launched a 5-point plan for the reform of family law, in order, they said, to bolster family stability, end financial injustice, and remove acrimony from divorce. One of these points was extending civil partnerships to opposite-sex couples, which has now happened very recently. Another was the reform of the ground for divorce, so as to get rid of the conduct-based reasons for finding that a marriage has irretrievably broken down. In England and Wales, 56% of divorces are based on adultery or behaviour, but in Scotland, only 6%. This is partly because the non-conduct-based facts require only 1 year's separation with consent and 2 years without it. The Times wanted to adopt the Scottish solution, but it works in Scotland for cultural and procedural reasons and might not work here. We've got so used to the quickie divorce after adultery or behaviour. A much better solution was proposed by the Law Commission back in 1990. Day one or both parties formally declare that they believe that their marriage has irretrievably broken down. Day 365, one, not necessarily the same one, or both, declare that it has indeed broken down. In between, the property, finances, and arrangements for the children could be sorted out, though doing so would not be a condition of getting divorced. The Family Law Act 1996 enacted a much more complex version of this scheme, which was generally thought unworkable and so was never brought into force and is now repealed. But a large-scale and serious study by Liz Trinder and her colleagues not only confirmed all the things we had thought wrong with the law all those years ago, but also adopted our solution, with the waiting period reduced to 6 months. Another spur to reform may have been the public's reaction to the Supreme Court case of Owens and Owens, in which we held that we couldn't interfere with the judge's decision that the husband had not behaved in a way which meant that the wife could not reasonably be expected to live with him. So they could not be divorced, even though their marriage had irretrievably broken down. On the whole, the media coverage of that case was entirely sympathetic to the wife's wish to be divorced from the husband with whom she had not been living by that stage for some time, and not making her wait the full 5 years until they could be divorced. Anyway, miraculously, in 2018, the following year, the government issued a consultation paper proposing the Trinder solution. This would have been unthinkable 20 or 30 years ago, but it obviously makes the dream of online divorce decrees much easier to achieve. A bill was introduced in June 2019, and in June 2020, the Divorce, Dissolution and Separation Act was passed. Though it's not yet in force, it is remarkably like the Trinder scheme. Never say never in law reform. I always tell my Law Commission colleagues, you never know when your proposal is eventually going to meet the mood of the day and will be enacted. A third Times proposal was ending the outdated and patronising meal ticket for life that can result from present laws on splitting assets and awarding maintenance after divorce, except where hardship would be caused. They could have added as in Scotland, but didn't. Now, this is a radical attack on our flexible approach to tailor-made financial solutions when couples split up. They propose the equal sharing of the assets accumulated during the marriage, but no provision for future needs unless there would otherwise be grave hardship. This is more or less the law in Scotland, and the Divorce Financial Provision Bill introduced in the House of Lords by Baroness Deach would introduce something very similar for England and Wales. Her bill made some progress in the last session of Parliament, but lapsed on dissolution. It had its first reading in this session in January 2020, but as yet no second reading. In her view, the present law perpetuates the indignity of lifelong support, makes the law inaccessible to lay people, obstructs settlements, and entails heavy legal costs. Other countries, such as Canada, have recognised that the equal sharing of assets on divorce is certainly an advance on who own the assets. Just going to get rid of that. There we go. Anyway, equal sharing of the assets is certainly an advance on the law as it was beforehand, when everything depended on who owned the assets, usually the husband, but it is not enough to give each party a genuinely equal outcome. Sometimes the imbalance can be corrected by an unequal distribution of the assets, giving each party the clean break which most people want. Sometimes it can't, and in that case, the gap can be made up by periodical payments. An example is the Supreme Court case of Mills and Mills in 2018. This was wrongly billed as an opportunity for us to abolish the meal ticket, but in fact, it was an illustration of how periodical payments can level the playing field. In their guidance for the courts, the Family Justice Council has endorsed the view of the Law Commission that although the objective of financial orders to meet needs should be to enable a transition to independence, in some cases independence is not possible. Quote, usually because of age, but sometimes for other reasons arising from choices made during the marriage, end quote. Note those words, arising from choices made during the marriage. Both a criterion and a reason. In the Council's view, it is generally right and fair that relationship-generated needs should be met by the other party if resources permit. We can't ignore the fact that marriage is a partnership in which the spouses often play different roles, and often varying over time, for their mutual benefit and that of their children and other members of the family, such as their elderly parents. This doesn't necessarily depend upon gender, but in practice it usually does. An ONS survey published only last week showed that during the pandemic, women have spent much more time than men on unpaid household work, unpaid childcare and homeschooling, and their mental well-being is suffering more than men's. Women often incur a motherhood penalty in terms of lower earnings and pension entitlements. The impact of divorce is on average considerably worse for wives than for husbands, whose incomes on average increase following divorce. Someone who gives up work, even for a few years, in order to concentrate on childcare or other family responsibilities will never make up what they have lost. Yet the most prevalent family form is a man in full-time work and a woman in part-time work. So despite all of that evidence that maybe on occasions financial support may be needed for a while after divorce, Emma Hutchins and Joe Miles have shown that there is no meal ticket for life. Clean break culture is prevalent. Periodical payments for spouses are largely confined to cases involving dependent children, and variations between courts may be more a product of local wealth levels and housing costs than differences of interpretation of the law. In their view, rather than being undignified or reflective of or reinforcing a victim mentality, orders that acknowledge the economic impact of how a couple have chosen or have been required by circumstance to raise their children protects the dignity of the primary carer, more fairly distributing between the parties the full economic impacts, positive and negative, of their marital partnership. So you may have guessed that I am not wholly in favour of a further development of family law in the direction which Baroness Deitch's bill would take it. And a fourth item in the Times campaign was to give prenuptial agreements the force of statute. If you've read my dissent in the case of Radmacher and Granatino, you will know that I have reservations about pre-separation agreements, whether made before or during the marriage. Although they may produce clarity and certainty, the object is almost always to provide for less than the receiving party would otherwise be entitled to expect. Nor can the vicissitudes of family life be reliably foreseen. The Law Commission has proposed that, to be binding, the person wishing to enforce such an agreement would have to show that certain obvious procedural safeguards had been complied with, and such agreements could not contract out of provision for need. Baroness Deitch's bill also gives legal force to marital agreements, but does not contain that exception, understandably because she doesn't believe in provision for marriage-generated need, and it puts the burden of proving that the safeguards have not been complied with on the person wishing to avoid enforcement of the agreement. So that's another item that I hope won't be taken further in the future. The final item on the Times list was providing financial remedies for unmarried cohabiting couples. Now, this is long overdue. More and more couples are choosing to live together without getting married. Although many of them may eventually decide to tie the knot, this comes much later in the relationship than it used to do, and sometimes it never does. There are several reasons for this. One is the pervasive belief in the myth of common law marriage, that in some magical way, living together for an uncertain length of time gives you the advantages of marriage. Another is the equally pervasive belief that marriage remains a patriarchal institution to which no self-respecting feminist, whether male or female, could subscribe. That was a large part of the motivation for wanting civil partnerships to be extended to opposite-sex couples, despite the fact that their legal consequences are virtually identical to marriage. Another reason may well be that the children no longer suffer both the legal disadvantages and the social stigma which they used to do. But I believe that a powerful reason for not getting married must be that it takes two to tango. Both parties have to agree to formalize their relationship, and one may be a great deal keener to do that than the other. In particular, now that the economically more powerful spouse may have to share more of his or her wealth with the other, and they can usually get sex without it, has marriage become less attractive, and in particular, less attractive to men? The increasing popularity of prenuptial agreements suggests that at least some of them do indeed think this way. Increasing cohabitation outside marriage or civil partnership means that there are many couples who have no financial remedy to sort out their home and finances when they break up. Until the House of Lords decision in Stack and Dowden, it was not even assumed that if they bought a home in their joint names, they intended to share it equally, unless a contrary intention could be shown. Same problem used to apply to joint bank accounts. But ownership doesn't solve all the problems. It can't deal with the totality of the couple's assets in a way which fairly represents the economic consequences of their relationship. There's a perfectly simple model available in Scotland, or at least it became rather simpler once the Supreme Court got its hands on it in Gowan Grant, but the UK government has resolutely refused to adopt it for England and Wales. The unspoken reason may well be that it is so necessary that it would be used, thus placing even more demands on the hard-pressed family court, albeit in a good cause which should reduce the demands elsewhere in the justice system. There is another group of people who are currently denied financial remedies when things go wrong. These are the growing numbers of members of religious faiths other than Christianity who celebrate a religious marriage which is not recognized in the law of this country. A comparatively small proportion of mosques, for example, are registered to perform marriage ceremonies. So the couple will have to go through another civil ceremony if they want to be validly married in English law. It would not surprise me if many, especially wives, did not realize this. It would also not surprise me if some, especially husbands and their families, made a deliberate choice to avoid the consequences of a valid English marriage. If things go wrong, the wife will be reliant on whatever she is granted by a Sharia council or Beth Din or other religious body, which may well be less than she could expect if she had a financial remedy in the family courts. Some, of course, may believe that they are validly married in English law. Are these couples not equally deserving of a financial remedy? But one important item was missing from the Times list: improving protection from violence and abuse within the home. Here, I believe that the problem is not so much the law as its implementation. There is a serviceable set of remedies in Part 4 of the Family Law Act 1996. Although it is debatable whether this century taking enforcement out of the hands of the family courts and putting it into the hands of the police was a good move. Getting rehoused should have become easier since Yemshaw and the London Borough of Hounslow. There, the Supreme Court held that violence in the homelessness legislation wasn't limited to hitting or threatening to hit, but could include a much wider range of harmfully abusive behaviour. I'm not sure that the message got home, because the Domestic Abuse Bill aims to make it clearer. There's much else that's helpful in the bill, in particular the obligations it puts on public agencies, rather than on victims to take action. But we shall have to see how it works out in practice. So to conclude, my own pet project for family law in the 21st century is more mundane, replacing all the multitude of separate processes in the family justice system with a one-stop shop, a single application form when anyone wants to start a family proceeding, telling the story and applying for whatever remedies are sought: divorce, short-term protection, child arrangements, financial remedies, to be followed by a single witness statement with annexes where necessary, providing the necessary evidence, with, of course, a single response in return. For as long as the current crisis in the family courts continues, and that will be long past the current pandemic crisis, we need to find a better way of tackling it. So that is my main hope for family law in the 21st century. But I hope I've shown you that we've made some radical steps already, and it'd be interesting to speculate on what the future will hold. Thank you.
Thank you very much, Lady Hale. We do have one question in our question and answer box here, and I would encourage, we have a lot of attendees here. If you have any questions, please put them in the Q&A box. You can see a little question mark symbol that you can put the questions in. We have one already. It's actually two questions and quite long, but I think I will sum it up slightly and ask, do you believe that in fact the family court system is biased against men? That men are treated more harshly when, for example, they want to get access to their children, that perhaps the mother is not given any sufficient deterrent to break arrangements for the children to see their father. So is it in fact against men, and should there be more men's equal rights in family law?
Well, that's, of course, a very good question. It seems to me that if you are a man, you may very well feel that the system is stacked against you. And if you are a woman, you may very well feel that the system is stacked against you. I don't believe that for the most part it is. The laws are gender neutral, and they should give equal weight to the interests of both parents in relation to their children. You will find as many women complaining that they are obliged to make impractical arrangements and bear the burden of enabling their children to see their fathers, as there are men who think that women are making life difficult for them. There are even more women who complain that they only wish that their children's fathers would take more of an interest in their children's futures and actually come and do something practical to engage with them. But we have taken the view that while contact orders, or child arrangements orders as they now are, can be enforced against the person with whom the child is mainly living, and in theory they could be enforced against the other parent, in practice they aren't. So I don't believe there is bias either way, but I believe that people do feel from time to time that there is such.
Thank you very, very much. The next question that I have is one that's been put forward by one of our students saying, what kind of remedy can someone like Jerry Hall be entitled to after thinking she was married to Mick Jagger for 9 years in Bali in 1990? So where people are deceived into believing perhaps that they're married when they're not.
Yes, well, that comes back to what I was talking about earlier. Jerry Hall is a celebrity example of that. I think she has other ways of seeing herself right somehow. But the final group of people that I talked about, which are the people who have a religious marriage without having a civil marriage, are very much in that group of people who they may have a contractual remedy in relation to their dower, because that may be contained in an enforceable contract, but that is very little. And they do need a remedy from the family courts. That is the reform, apart from the procedural reform that I mentioned, that is the reform that I would most like to see out of all the outstanding matters, that there would be ways of giving financial remedies to recompense losses and disadvantages arising from the relationship, or corresponding advantages from the relationship gained by the other party. Making those available to unmarried couples is, I think, a priority in law reform. But it's been around as a priority for a very long time. And as I said, the UK government doesn't seem too keen on it. Perhaps the Jerry Hall type example, though put into the context in which I put it, would be a way of spurring the government into being more sympathetic than just talking about people who might very well get married but simply choose not to do so. They always say they choose not to do so, but as I pointed out, maybe it's only one of them who's choosing not to do so. And the justice isn't always as simple and clear as all that. But I agree with you.
Thank you. Another question we have here is,
sorry, excuse me, Sandra, I should perhaps just mention that in certain circumstances there will be a remedy if the marriage counts as a void marriage in English law, because then you can get a decree of nullity and you can get financial remedies ancillary to a decree of nullity. But that depends upon extremely complicated law about what is and is not a void marriage, and it's by no means clear when lack of formalities mean that it isn't a valid marriage. Sorry, I should have pointed that out.
Thank you very much. I have another question here. Would simplification of the law lead to rash decisions and effectively support a society happy to make short-term and often knee-jerk decisions?
I don't know the answer to that one. We never know what the consequences of changes in the law are going to be. But I'm not sure that anything I'm suggesting amounts to much of a simplification. Clarity is important, but simplicity is not always the road to success. But clarity is, even if it's a discretion, clarity about the principles according to which the discretion will be exercised is a good thing. That's why we have a checklist in the Children Act, so that the court can go through the factors which are relevant to the child's welfare in a systematic way and think about them and explain them to the people concerned. So now I'm not sure I'm in favour of too much simplicity. Simplicity of remedies is a very different thing from perhaps that's who you're referring to, my one-stop shop idea, but that's not going to change what the actual law about those remedies would be. The actual law would be the same. It would just be that it would be, you would not have to fill in 4 or 5 different application forms with 4 or 5 different witness statements saying exactly the same thing. If you've been in the family courts and you've got the file which deals with one set of proceedings, the file that deals with another set of proceedings, you see what an awful lot of duplication there is. And although, of course, there are people in the profession who benefit from that, I cannot think that it's a good thing overall. And in these days when so many fewer people are legally represented, simplicity of procedure is a very good thing.
Thank you. Another question here is, do you believe that because the United Kingdom has a state religion, it has limited the development or acceptance of other forms of marriage?
Well, undoubtedly, the idea that marriage is limited to one man and one woman, or now one man and one man, or one woman and one woman, does have its roots in the Christian idea of marriage, which is why I quoted the 1866 case. But what it now excludes, of course, from taking place in this country is a polygamous marriage, whether potentially polygamous or actually polygamous. That is the thing that is excluded. And there are arguments in both directions about that, which is why I just floated the question. Is that something that is going to get thought about in the future? There would undoubtedly be communities who would be in favour of it. The argument in favour of allowing polygamous marriages is that it then gives status and legal rights and responsibilities, but basically legal rights to the less advantaged party to the marriage. So although outlawing polygamous marriages was seen as protecting women, basically, in practice, if they're going to take place anyway, it doesn't protect them. And that is why in 1972, the law was changed so that you could get a divorce and financial remedies if there had been a valid polygamous marriage abroad, but we still don't allow them here. Yeah.
Thank you.
Just talking about the state religion, yes, well, we do have a state religion in England. We have the Church of England, which is the established church. There isn't a state religion in Wales, and there only slightly is in Scotland, although the Church of Scotland does have certain statutory protections. But the English are the least religiously observant of probably anybody in Western Europe, but certainly anybody in the United Kingdom. So I'm not sure that the Church of England has any great influence on the development of family law any longer.
Well, thank you very much for that. A question here actually from one of my colleagues. do you think common intention constructive trusts are really just family law remedies squeezed in under the umbrella of trusts law?
No, I don't. And you wouldn't expect me to say that they were. There will be certain people who level that accusation at the decisions of the House of Lords in Stack and Dowden and the Supreme Court in Jones and Kernot. The worst accusation to hurl at both of those cases is the one encapsulated in some article which said, do as I say and not as I do. Because in both of those cases, we actually decided that the presumed common intention had been rebutted. But the basic notion, which is the fundamental underlying one, that if you put a property which is intended as your joint home into joint names, you intend to own it jointly, both beneficially and in law, seems to me to be perfectly reasonable, rational, and to accord with most people's assumptions. That's what people are told when they put property into joint names, that it will automatically be jointly owned and the right of survivorship will apply if one of you dies. And of course, so for the great majority of married couples who buy properties in their joint names, they will assume that if one of them dies, the survivor will automatically inherit the house. And that's a much more common situation than divorce is. And so having that as the assumption, the presumption, it can be rebutted, but having it as the assumption accords with everyday reality. And the reverse presumption, that the ownership is in proportion to the financial contributions to it, is only a presumption and not necessarily in accordance with reality. It may be in certain commercial situations, but it is not necessarily so in family situations. So no, I do not think it's a family remedy imposed upon land law and trusts law. I think it's a perfectly rational approach. But I would say that, wouldn't I?
Right. I mean, I have another interesting question here from one of our postgraduate students asking, she's saying, thank you for the fantastic talk. And she says, do you think there will be a shift in respect of child autonomy as we move further into the 21st century? She's thinking particularly about medical decisions.
Well, there already has been a very considerable shift in favour of child autonomy. The well-known Gillick decision was such a shift, a quite dramatic shift in the circumstances. There is still an area of the law which is quite difficult to work out, and that is the extent to which the parents or the courts can override the child's autonomy interests. I myself take the view, which is I think generally taken, that once the child has reached the age where they're old enough to make their own decisions, they are old enough to say no as well as to say yes, and that the parents can't make a different decision for them. But the court can. And of course, it's very different if a court makes a different decision, because the court will have heard both sides of the story and will have worked out what the arguments are. It will almost always decide in favour of life-saving treatment. In fact, it will always decide in favour of life-saving treatment. I think I can be pretty confident about that, unless it's completely futile, as in one or two tragic cases that we had in the Supreme Court not very long ago. But I myself do not think it's the law that the parents or a local authority with parental responsibility can override the refusal of a child who is Gillick competent to consent to treatment. That happens to be my view.
Thank you. My next question actually follows on a bit from that. which is quite an interesting question from one of our undergraduate students. How do you see the progressive nature of the trans rights having an impact on the future of family courts, especially if one parent may not agree with the other about transitioning and the well-being of the child being questioned?
Well, obviously, if parents are in disagreement about this, then it can only be resolved by a court. And the courts have taken the view that the child, herself or himself, is unlikely, at least below the age of 16, to have the capacity to consent for themselves. Or then the court would have to work out the welfare arguments in relation to transitioning on the evidence. That's the great thing about courts. They may take a long time, they may be expensive, all of those things, but they do listen to all sides of an argument and try and make a decision in accordance with the evidence that they have heard. So that's what should happen in that situation.
Thank you. I mean, I have a question here which says, should the Section 1 of the Family Law Act 1987 change in the future in favour of the protection of the unmarried child?
Protection of the unmarried child?
Yes, that's what the question says.
I don't quite know what the questioner is getting at in relation to that. The Act is about protecting the children of unmarried parents, whether those children are married or not, because it applies to relationships of people who are married just as much as it applies to relationships of people who are unmarried. So I don't quite understand the question. Sorry.
Thank you. A rather different question here. As a result of the COVID-19 national lockdowns, do you think that courts will see more family-related cases, for example, divorce? Are people going to have got more fed up with each other in lockdown and there'll be a higher number of divorce cases?
Well, I did look at the figures so far as they're available, and then, you know, the most recent ones are not available to see. There has undoubtedly been a substantial rise in domestic abuse cases. There hasn't yet been much of a rise in divorce cases and the associated remedies that go with divorce cases. There's been a little bit of a rise, but nothing very significant. But there has been a rise in domestic abuse cases, and that, of course, may work its way through into a rise in divorce cases in due course. None of which is surprising. There's been also a rise in the demand for services, refuges and the like, protecting people against domestic abuse. You are right.
Okay, thank you very much. I have a question here from actually our Dean of Faculty, and he is asking, he's actually a computer expert. He's asking, would family law be easier or harder to be considered by artificial intelligence or AI judges than other areas of the law? And if so, how?
The granting of a divorce under the new process, not yet in force, in the 2020 Act, perfectly well be done. In fact, I'm not even sure that you need to call it artificial intelligence. I think it can just be done by filling in a form in the same way that you apply for a driving license or to tax your car or whatever. Perfectly simple. But the evaluative judgments, where there is disagreement about what should happen to the children, the home, the finances, the savings, or whatever, that I would hope would not be done by artificial intelligence, partly because there are facts to be found, which is difficult to do, by artificial intelligence, and partly because there is evaluation, which it may be possible in the future to devise a system that would be able to do it sufficiently sensitively. But the problem, as we all know, with algorithms is that they are based on what has happened in the past, extrapolated to the future. And that isn't necessarily a sound basis for deciding on the circumstances of an individual family, because we know that all families are different from one another. And there is a famous saying that while all happy families are alike, all unhappy families are very different from one another, unhappy in their own particular way. So certain processes, yes, can easily be automated, but not the evaluation of disputed facts and outcomes.
Thank you. I think perhaps leading on from this, we have a question from our clinical legal education manager about, with the introduction of a single application form or one-stop shop, as you were talking about, create more freedom for parties to conduct their own proceedings, thus improving access to justice?
Well, that's part of my feeling about it. Yes, it would, because it would have to be automated in a way that people could go through the process for themselves, and then decide for themselves whether they could agree on an outcome, as long as they had enough links to appropriate information. And at the moment, the links on the various websites are very fragmented. It's very difficult to get a complete picture of what the court will be interested in if you go to court. And I think there's a big piece of work to be done in trying to get appropriate public information in a way where each bit that you want easily links into the other. But if that could be done, well then yes, it should help people to be able to decide that they don't actually need to go to court because they can sort it out between themselves. And the form can perfectly well say, if you would like help to try and sort it out between yourselves, well, here is a link to various mediation organisations which could help you. It could easily do that.
Thank you. I know the Vice-Chancellor said he had one or two questions. I don't know whether you'd like to ask one now, James. You have to unmute yourself first.
Yes, I have to. I always criticise other people. No, thank you so much for a really interesting talk. But I was quite interested in following up that discussion, that one of the later points you made about marriage being less attractive to men. And then you followed up with a discussion that actually you felt it was fair to men and women, that there were equal decisions here. So do you, is it then just a psychosocial explanation, or has the law changed in certain ways to make it appear at least less attractive to men?
Well, yes, it has, if you look at it objectively anyway. But that happened in about 1971. Before that, the law really was based on an assumption that there would be a breadwinning husband and a homemaking wife. And the remedies available to the homemaking wife were much less generous than they are now. She couldn't get a share in the home unless she had financially contributed to it. She could only get maintenance, periodical payments, if they separated, if she was substantially, completely innocent in their separation. She would have to prove that the husband was to blame for it. And if he could prove, and this is certainly in the magistrates' courts, even long after they had separated, she would lose her remedy if she had one act of adultery while they were still. So and she would also have a chance of losing her children as well. So a homemaking wife who was divorced had a quite strong chance of losing her home, her livelihood, and even her children, which was a very strong incentive to stay at home and in line. Now, I am putting it quite strongly because obviously in the great majority of cases, this wasn't how things worked out. But you could see that it put that combined with the way society was organized until radical changes started to happen in the 60s, meant that the man was in a much more powerful position. Now, family law basically changed all of that in terms of the remedies available in the reforms that came into force in 1971, which meant that the assets could be shared out equitably. There could conduct on either part became largely irrelevant to how the finances were sorted out. Until 1972, a married woman had no automatic rights and authority over her children.
Okay.
Just you know, I could go through it all the old history, but so that has changed, and obviously it is now more equal. And in fact, of course, high-earning women are now finding that the law is not as favourable to them as the men found some time ago that it wasn't as favourable to them. So there's a bit of a backlash coming from the high-earning women, but that's what I was getting at.
Okay, no, that's really interesting, and going back so far is fascinating to me. May I just have one follow-up question, Sandra?
Sandra's mute too, but yeah. So you've got to you can take it.
Yes.
And then I'll hand back to you, Sandra. But it was concerning no-fault divorce, and I apologise if I got distracted at one point. But I mean, there is, I'm sort of aware of a feminist critique of no-fault divorce, but also a feminist, push towards no-fault divorce. And I just wondered which side you came down on there. And if you said it already, I apologise, but it's quite important to me to know that.
Well, I am very much in favour of no-fault divorce. We're talking about here about the reasons for dissolving a marriage. We're not talking about the consequences of dissolving a marriage, but the reasons that you have to prove for dissolving a marriage. And under the present law, the sole ground for dissolving a marriage is that it's irretrievably broken down. But you could only prove it by proving one of 5 facts, one of which is adultery, another of which is that one party has behaved in a way which means that the other party cannot reasonably be expected to live with them. This is usually said to be unreasonable behaviour, but that, of course, is a misnomer because it's not that, it's focusing on the effect on the other party. But there we go. And the majority of divorces are on one or other of those 2 bases. They are hardly ever contested because there is no real point in contesting them. You're unlikely to succeed in contesting them, fairly obviously. And if you do contest them, you're not going to save the marriage. In fact, you're going to drive the couple further apart. And so there's not a lot of point. And yet it will cost you, everybody, a lot of money and a lot of heartache and a lot of time and so on and so forth. And of course, it does make it much more difficult because of the bitterness that it engenders, the long list of accusations of the way in which somebody's behaved. It makes it much more difficult for the couple to cooperate in the consequences, what's going to happen to the home, the finances, and most importantly, the children. So it encourages an acrimonious approach, which isn't necessary. I mean, marriage breakup is horrible enough without the law adding to it in that way, unnecessarily, because it was thought that it would help keep parties together, but there is well, we know that it doesn't. There's plenty of research that indicates that it doesn't. So that's why I'm in favour of no-fault divorce.
Okay. Thank you. Thanks, Sandra.
Thank you. I think that we've kind of come to the end of the time. We've gone over the hour. There are a couple of other smaller questions in there, but I think we've answered the vast majority of questions. So, unless Lady Hale, you're very keen to continue answering questions, I would suggest that now is a good moment to bring proceedings to an end.
Well, those two very good questions from the Vice-Chancellor seem like an appropriate way to bring things to a close, and it's been a great pleasure for me to be with you.
Yeah, it's been an extraordinary honour for us, isn't it, Sandra? I mean, I'm not sure which of us is going to say the final word there, but let me just say this, and then Sandra, you close. But it's been a great pleasure, Sandra. This Baroness Hale, this wasn't my area at all. I've learnt a lot, and I could actually listen to you for another hour or two or three, because you explain things so well. So I've really enjoyed this, and it's a great honour for us to have you here with us at the University of Buckingham. Sandra.
Yes, thank you very much, Vice-Chancellor, and thank you very much, Lady Hale. It has been, I think, one of the best events that we have put on. It's been absolutely wonderful to hear you speak and to actually hear your very, very clear and lucid arguments that you put to all the questions. I feel I've learned a lot, because family law isn't my area, though I do a bit of property law. So I have read Stack and Dowden and Jones and Kernet in great detail. Yes, thank you very much. Thank you on behalf of all our students and the staff and the university for coming. And it's been a wonderful occasion.
Yeah.
Well, thank you.
Thank you.
And goodbye.
Bye-bye. Bye.
Goodbye.